after the war, the International Court of Justice, and then afterwards we have had this almost explosion of different international courts in different fields, which are different in the sense that they are specialized, they are dealing with special issues. In addition, of course, we have arbitration and permanent court of arbitration in The Hague, which comes in addition to the permanent courts. So this has been very promising, and there were hopes that the world was now moving in a direction of more rule of law at the expense of power, that power was controlled by rule of law to a greater extent. It's also interesting that these new courts, it's not only more courts, it's also some different kinds of courts, in the sense that they are to a greater extent compulsory. It's not up to the states to accept them or not. Of course, they are based on consent, but in order for the states to benefit from a treaty, they have to accept the court, which is also part of that particular regime. So if a state wants to benefit from trade, it has to become a member of the World Trade Organization, the WTO, and it has to accept the dispute settlement of the WTO. So one can say that de facto they have become compulsory. If states want to be parties to the Law of the Sea Convention, they have to accept the dispute settlement under the Law of the Sea Convention. If they want to be members of investment treaties, they have to accept the dispute settlement under the treaty, etc. So if they want to benefit from what the treaties can give them, they have to become members also of the courts and the tribunals under these same treaties. So that's one thing. Another thing is that some of these treaties open access not only to states but also to individuals and to companies. Human rights tribunals are open also for individuals. Investment tribunals are open to companies, and that means that these courts and tribunals are more used. States are reluctant to go to court against another state. Individuals and companies may be more open to it. So that means that we have more cases, we have more jurisprudence, which is also creating more rule of law governance of the world. So in combination, this means that international courts have been more important, and also the rule of law. What about Asia? We don't have many regional courts in Asia, as opposed to some other regions. It is a question to what extent Asian states and China uses global courts. A study by Simon Chesterman, he found that Asian states have the lowest rates of acceptance of the compulsory jurisdiction of the International Court of Justice and of the membership of the International Criminal Court, and fewer states have joined the World Trade Organization. So there are fewer regional courts, and fewer states have accepted the jurisdiction of global courts. But we see, for example, with the WTO system, China is one of the strong supporters of the WTO system. So it varies between courts, and it varies between different countries. Then we see that international courts are increasingly contested, that they are criticized among states, but also among other actors in international law, whether it's NGOs, individuals, companies, etc. One example is the European Court of Human Rights. This picture illustrates the so-called crucifix case. It was a case concerning Italy, and in Italy all the schools have crosses in the classrooms, and the question was whether that was a symbol of the national culture or whether it was a symbol of religion. And Italy claimed that this is a symbol of the national culture, it's not a symbol of religion. And the court first disagreed, and then the case was, the judgment was appealed, and the Grand Chamber of the European Court accepted these crucifixes in Italian classrooms. But what we are seeing is that several states now criticize the court for going too far in the interference in national sovereignty. And we see it both in different parts of Europe. We see it from Russia, where the Russian Constitutional Court has said that certain judgments are against the Russian Constitution. We see it in England, United Kingdom, which has criticized the court's judgment concerning giving voting rights to prisoners, and saying that this goes beyond what the European Convention on Human Rights says. Denmark has been critical when it comes to rights to immigrants to Denmark, etc. So that means that criticism of the court is taking place in many different countries, and also among countries that were the traditional supporters of the court, and that is something new. The court is a success in the sense that it has too many cases that creates a problem for the court, but that is a criticism against the member states. They should deal with human rights obligations at the national level, so that persons don't have to take the cases to the European Court. But the European Court has currently about 60,000 cases pending before it, so that's a big problem. This is the SADC court, which was and is based in South Africa. The problem with the SADC court was that it got a case concerning property rights in Zimbabwe, and it concerned white men, owners of land in Zimbabwe. And of course that was not very popular for the government. So the government did not accept the judgment from the court, which was in favor of the landowner. And the Zimbabwean government decided to fight against the court, and they chose the approach of not accepting renomination and election of new judges. So over time the court just died. Now it has been re-established, but not allowing applications from individuals, only between states. So that was an attack on the court. We have the ICSID and investment arbitration, which has been criticized. Some states have left it, but it has been criticized partly for being too favorable to companies as opposed to states. It has been criticized for having secret deliberations and secret judgments, so criticized for lack of transparency. It has been criticized for using the same arbitrators all the time, male, white, old arbitrators, instead of using arbitrators from all over the world. So it has been criticized, and there is a reform process going on now. We don't know the outcome of this process. We have the International Criminal Court, which has been criticized for being selective, in the sense that it has dealt, at least until recently, only with cases in Africa. An African state has criticized the court for being biased. Why don't they go after countries or persons on other continents, waging wars, etc.? And now the court seems to go beyond Africa, concerning Afghanistan, Georgia, Colombia, etc. But of course that creates criticism from other parts, and we had recent very strong criticism from John Bolton in the US a couple of weeks ago, which even threatened to adopt sanctions against the ICC judges if they wanted to prosecute American individuals. So there we see that the court is attacked both from Africa and from the US. Of course, the US is not party to it, but they fear that individuals from the US can be prosecuted. And then we have the Law of the Sea Tribunal with its arbitration system also. And I've listed there Russia and China. Some of the problems with the International Tribunal for the Law of the Sea is that it has not attracted enough cases, so the court is a bit concerned that it should have more cases. But to the extent that it has had cases, it has mainly been through the arbitration system under the Law of the Sea Convention and not the court as such. But in a case, the Arctic Sunrise case, Russia rejected to meet before the court. So the court continued, or arbitration continued, in spite of Russia not meeting before the court. And the same, to some extent, applied to the South China Sea with China. There China submitted a position paper, so China participated to a certain extent, but not formally in the negotiations. So one can discuss whether that is a protest against the dispute settlement system as such, or whether it is a criticism against the legal analysis by the court, or of the composition of the arbitration tribunal. So that is a matter of interpretation. But this shows that there are several courts that are being criticized and that are being attacked. The International Court of Justice has not been attacked that much, but in an earlier lecture here I was asked about the nuclear weapons, or the disarmament obligations, where the court was split very much along the lines of judges coming from nuclear states and non-nuclear states. And that resulted in the UK changing its declaration concerning the optional clause. So the UK limited the jurisdiction of the International Court of Justice as a result of that particular case. The WTO appellate body has long been seen as a success story, established with the WTO in 1994, and has had a great success in its jurisdiction. But now the system is under attack again from the United States, which uses in some sense the same tactic that Zimbabwe used when it comes to the SADC court, not renewing the membership of the appellate body members or accepting new members to the appellate body. So the appellate body has 7 members. It needs to have 3 members in each decision. So they started with 7, and then they had 6 members, and then they have 5 members, and now I think they have 3 members. So if one of the members gets sick, it is not able to give any decisions, and soon there will only be 2 members, and then the appellate body is not able to give any decision, so that would destroy the whole system. We know Brexit, the UK possible withdrawal from the EU. Of course, that is in a sense a protest against the whole system, but also against the European Court of Justice. So that's part of it. Again, if we think of China, there was a Russian-Chinese statement in 2016 saying that it is crucial for the maintenance of international legal order that all dispute settlement means and mechanisms are based on consent and used in good faith and in the spirit of cooperation, and their purposes shall not be undermined by abusive practices. That could be seen as a support to dispute settlement, but it could also be seen as an implied criticism of dispute settlement or a threat to future dispute settlement. That is a matter of interpretation, I think. But it could be seen as a warning concerning international courts and tribunal. So this raises the question whether this is a general backlash against international courts, or whether it's a different backlashes against different courts, and how serious they are, and what kind of criticism is voiced. It is also a question to what extent some part of this criticism is justified, because one should listen to criticism and see whether there is some good reason for the criticism and whether something should be changed. So that is also a question. So we should be concerned about the criticism, but we should also think of whether some of the criticism is justified. So if we look at the reasons for criticism, some of it is that I use ICs as short for International Courts and Tribunals. So some think that the international courts and tribunals are selective and fragmentary, and that is a problem. Of course, we don't have international courts in all areas. We don't have an international court for the environment. We don't have an international court for development. We don't have an international court for peace. We don't have an international court for social justice, etc. So there are several areas in international law where we don't have a court, and it could be criticized that we should have courts also in these areas. And it could be claimed that there is a danger that in the areas where we have courts, that could be a threat to the areas where we don't have a court. For example, it may be important to adopt decisions in the relationship between trade and environment. And if there is a trade court that shall make decisions concerning trade and environment, that could be in favor of the trade interests rather than the environmental interest. Also because the trade court may be composed of trade specialists and not by environmental specialists. So one can imagine that the areas that do not have an international court is threatened. And there has also been discussion about the fragmentation of the international judiciary. I will come back to that, whether that creates problems about contradictions between different courts and who shall decide in the final end. We don't have a super court, we don't have a supreme international court, so who should decide if there are different decisions by different courts? International courts bite, but according to their purpose is the question. Yes, of course, international courts means interference with national sovereignty, but that is necessary in order to have international obligations. So states have to accept limits on their state sovereignty in order to have reciprocal obligations between states. One can discuss whether international courts deliver too much, whether they go too far, or whether they deliver too little, that they are too cautious. So that may be opposite kinds of critiques against international courts. One can discuss whether they are independent or whether they are dependent on states or other interests, or one can discuss whether they are too independent, whether it's the rule of lawyers rather than the rule of law. So there is a balance there between independence and accountability, which I will come back to. They may be seen as biased. That is, as I said, the claim against the International Criminal Court, that they are against Africa. In investment courts, as I said, has been said to be against the states and prefer companies and so on. So it's a question whether they are biased towards certain interests and not other interests. Then we can discuss whether there is too much internationalization and whether there is too much judicialization. So should more power be left to national states rather to the international level? And if it should be left to the international level, should it be left to courts or to other organs? I will come back to that also. And then we have the recent populist critique, these more emotional sentiments in different countries towards more nationalism, chauvinism, etc., which are not necessarily based on facts, but more on sentiments, but which may have important effects on international cooperation, including international courts. And then finally we could ask, okay, we need to resolve disputes, but maybe we could resolve disputes through other organs than international courts. I will come back to that also. So there are very many reasons or possible reasons for critique against the current international system with the courts. So then I move to what we are concerned with at our Curie Court Center in Oslo, we are concerned about the legitimacy of international courts. So what do I mean by legitimacy? I will come back to that also, but it is a question about to what extent certain organs should have the right to rule. Why should certain organs have power to rule over others? That is the question of legitimacy. Are they justified to rule over others? And then we can discuss these issues in relation to several courts, human rights, trade, investment, etc., etc. But then we have defined 5 research topics. First, we have to address which legitimacy standards do we apply? What kind of standards should these courts respect? And then we have listed 3 different areas: multi-level separation of authority, independence and accountability, performance, and then we ask about comparative advantages. And I will go through each of these different standards. So here is the legitimacy question. Why and when does an international court merit deference or respect by different other actors, whether they are states, international organizations, other international courts, companies, individuals? So why should they be respected? One answer would be that states have consented to them. So that is the basis for most of international law, and as a basis for legitimacy in international law, that the obligations and the institutions, including courts, have been consented to by states. But we see that when international organizations and international courts get more power, we need additional criteria for legitimacy. It's not enough with state consent. So what are the additional basis of legitimacy? When it comes to courts, it is easier to make the parallel to the national level. So we ask, what kind of standards do we use at the national level? Using constitutional standards, public law standards about independence, about procedure, about interpretation, etc. So that is a starting point, I think. But at the same time, we know that there are different standards in different countries. So then it is a question, well, which standard should we use? So that's one issue. Another issue is that it is always a question to what extent we can apply domestic procedures at the international level, because the domestic system and the international system is very different. So that is always the question of translation. Can you translate from the national order to the international order? And that is a more general question in international law, I think. And then this raises both legal questions, empirical questions, and normative questions. The legal questions is how should the court interpret the obligations, in what way? That is the basis for legitimacy, that the court respects the law. Very important for international courts that they can be seen to respect the law. They should not be seen as political organs. They should be seen as legal and judicial organs. Then we have the empirical questions about how the system functions in reality. Do the courts fulfill the objectives that they were meant to fulfill? That is ideally something we can measure, although it may be quite difficult. And then we have the normative issues, which I referred to, about which standards should we apply. So these would be the three kind of issues that we should address when we ask about the legitimacy of international courts. So if we start then with what we call the research topic number 2, multi-level separation of authority. That can again be divided into two, because the first question is the allocation of power at the international level. If we use the domestic analogy that we have legislative powers, we have executive powers, we have judicial powers, we can ask, well, the court should exercise judicial powers, but not legislative powers, and not executive powers. They are not enforcement organs, so they should limit themselves to their judicial function. And if they go too far in the direction of legislative functions, that may create a legitimacy problem. So that should be left to other organs, like international organizations, to adopt conventions, to adopt decisions, etc. It should not be done by international courts. And as I said, enforcement is not a part of what courts should do. Enforcement should be left to executive agencies, which we don't have much of at the international level. But in practice, this can create problems. We had the issue earlier about Libya case earlier, to what extent the International Court of Justice could review decisions by the Security Council. Of course, it must be in an interstate case, but that question has not been resolved. Does the Security Council decide for itself, finally, what is in accordance with the UN Charter, or can the International Court of Justice decide that some decisions are ultra vires, they are in violation of the UN Charter? Another question, another issue is the relationship between the Security Council and the International Criminal Court. The Security Council can refer situations to the International Criminal Court, but what is the more detailed relationship between the Security Council and the Criminal Court? We have the issue that has been raised by African countries about the immunity of state leaders before the International Criminal Court. Do state leaders have immunity when they travel abroad? That was subject to proceedings in a case brought by Jordan, I think last week, in the International Criminal Court. But the African states have also, and the African Union has also thought about asking for an advisory opinion, go to the UN General Assembly and ask the General Assembly to give an advisory opinion whether the International Criminal Court has the right, or whether state leaders have immunity when they travel abroad, or whether they can be arrested and brought to the International Criminal Court. There we could have the possibility that the International Criminal Court and the International Court of Justice will come to different conclusions. So we have the possibility of a clash between different international courts also. We have seen it between the international and the regional level. For example, the EU court has said that some of the decisions by the Sanctions Committee of the Security Council is against the EU law and cannot be applied in the EU. That was concerning freezing of assets by a person that was claimed to be a terrorist. That can be seen in a way as a dualist question about the relationship between international law on the one hand and EU law on the other hand. So between a more domestic court and an international court. But this shows that there may be questions about what is rightly accorded to an international court and what should be decided by other organs. And then we have the question about allocation between the international level and the national level. So what should be decided by international courts and what should be decided at the national level. We have seen that some international courts use what is called standards of review, that they apply a certain deference, that they give some weight to decisions at the national level when they are making their own decisions. Quite famous is what is called the margin of appreciation by the European Court of Human Rights. So the European Court of Human Rights says that if the national courts have used the same methodology as the European Court, the European Court will generally respect the decisions by the national courts. And we have seen that to some extent also by other courts. For example, in the WTO appellate body, in some cases the appellate body will refer to decisions at the national level and say that this is up to the national organs to decide. Norway was engaged in a case with Canada concerning seal hunting against the EU, and the appellate body said that that it is up to the EU to decide whether seal hunting should be accepted or not. That was an exception in Article 20 of GATT. And the appellate body left the decision to the EU level, to the national level. So that is showing some difference, some respect, taking into account decisions at the national level. A third example is the International Criminal Court and the question of and the principle of complementarity. That the International Criminal Court will not act in a case unless the national courts are, or national organs are unable or unwilling to deal with the case. So the principle is that issues should be resolved at the national level and should only be brought to the international level if the national level is unable or unwilling to resolve the problem. So all of this shows a question of separation of powers between the international and the national level. And then we may have questions of binding versus non-binding decisions. An interesting example was a conciliation between Australia and East Timor concerning delimitation between Australia and East Timor in a recent case, was it a couple of months ago or something. So that will also give more power to the national level if decisions are non-binding, non-legally binding. So that is also a way of giving more power to the national level. So one issue in these days of criticism against the international courts is to what extent they should pay more deference to national sovereignty than they did before, but at the same time they should ensure that international obligations are effective. So that is, and that may be a difficult balance. Moving then to next questions about independence and accountability. What should be the right balance between securing that international courts are independent, but they should not be so independent that they are totally unaccountable? So how to find solutions that would satisfy both these requirements? This has been referred to, or one aspect of it, in an article by Jeffrey Donoff and Mark Pollack called Judicial Trilemma, in a recent article in the American Journal of International Law, where the authors say that there may be a need to balance the need for independence, transparency and accountability. That is the three elements, the trilemma: independence, transparency and accountability. Transparency in the sense of having the possibility of independent and dissenting opinions in the judgments. As you may know, the European Court of Justice does not allow independent opinions. In the appellate body there may be separate opinions, but they are not attributed to special members. So there is a limit in a way to what extent you can have independent opinions. So if you have independent opinions, then you have the possibility that states will sanction a judge which has a certain opinion, and not renew the appointment of that judge if they don't like the opinions of that particular judge. So that would that system would favor accountability, but it could be in tension with the independence. One way of dealing with it is what the European Court of Human Rights has done. There was a system with a 6-year appointment of judges, and then they could be reappointed for another 6 years. But then there was a fear that could have consequences for the independence of judges, and therefore the rule was changed so that the judges are appointed for 9 years, but without any possible of renewal, so that states cannot sanction the judge by not reappointing him or her. But of course they can sanction when the person comes back and wants a good job in the national judiciary